Good morning, everyone. Welcome to today's employment law update for the year 2023. My name is Carlos Alfaro, and I lead the Business Insurance Center at Insurnex. We're excited about today's conversation. Lots of changes taking place. I want to welcome and thank each one of you for joining us. I know we all have busy schedules. There's a lot of other places we could have been or we could be. So thank you for being with us today. A couple of notes before I introduce Oscar Rivas. Oscar has been leading our employment law updates for the last 9 years. He is an employment law expert and has supported conversations with our clients through seminars, through workshops, and at times with consultations as well. So one additional announcement and note that I want to make. Today's conversation, Oscar is going to walk us through the employment law changes taking place this year. And on February 22nd, we're going to have a follow-up conversation. So today's conversation is really introducing us to the legislative changes coming about. And then February 22nd, we're going to go into more of how do you take these laws and make them part of your culture? How do you embrace them? How do you implement them? And we'll put out those details as we get closer to those days. So without any further delay, it is my pleasure to welcome and introduce Oscar Rivas. And Oscar, welcome, and the floor is yours.
Thank you. Hello, everybody. Let me start sharing the screen so that I can do the presentation. All right. So hopefully everybody can see that. Well, I want to thank everybody for being here. I understand that everybody's busy, and you know, every year in October, the governor signed a bunch of laws. Among them is always a nice little package related to employment, new laws, new requirements, and sometimes there are tweaks to existing laws. And basically that's what we have last year. There are some tweaks to new laws, new rights have been implemented. And it was actually a decent amount. And because they're tweaking regular laws, the presentation is gonna kind of move pretty fast so that I can cover most of the things that will apply to most of the employers that probably, you know, these are kind of smaller employers that I'm thinking is in our audience. So so as Carlos was saying, I'm an employment law attorney. I've been practicing employment law since 2005. I've been an attorney for longer than that, but employment law since 2005. I've handled all types of employment situations, from wage and hour to discrimination cases, going to trial, advising counsel, advising clients in dangerous terminations, investigations, and all that kind of stuff. So I pretty much have seen most of it. I've done class action litigation. So I've seen a lot of the stuff that most employers face. I now have a practice where I actually try to advise clients before they get into litigation, although I do litigation. So that's basically me. So without further ado, let's get to this presentation. There is a lot to cover. At the end of the presentation, if you have any questions, please direct them. If we don't answer, the presentation has my contact information, should be an email. If it's please send me emails about general questions. Unfortunately, I cannot give you legal advice. So you know, but if you have a question about a particular law, please just send me the question. I'll be happy to, and they can submit the questions also to in the presentation. So here we go. So first, housekeeping issue. This presentation is for educational purposes only. If you have any situation, please consult an attorney or other HR professional that will take all the facts into consideration. What we give here is essentially just a summary of what it is. Each law takes into account different fact scenarios. And so if you have an issue, it's always a good idea to call rather than just assume that the presentation somehow resolves your issue. So, you know, the presentation is not intended to create any attorney-client relationship with you or somehow represent you. So if you have any questions, I'll be happy to hear general stuff, but I won't be able to answer any very specific questions that deal with me giving advice to you. But if you have any questions about coverage of the law, I'll be happy to answer those. So the first part that we're going to be doing is essentially the minimum wage changes. Up until last year, the minimum wage was in an upward trajectory. The law was passed about 5-6 years ago, where minimum wage was taken basically at $1 pace up until it hit 15. I think last year was the last time when even the smaller employees had to hit $15 an hour. But the statute that created that upward trajectory also had embedded in it an inflation adjustment provision, which then kicked in this year. So the minimum wage was $15 an hour, but with the inflation adjustment, and everybody knows inflation is pretty high, inflation went to took the minimum wage to $15.50 an hour. So at this point, the state minimum wage is $15.50 an hour. Now, understand that there's different cities, including the LA city, Santa Monica. There's cities up north, San Francisco, Emeryville, that have their own local ordinances, sometimes increase this right. But the state minimum wage is $15.50 an hour. But if you live in one of those cities, or you might want to double check whether the city has a higher requirement. But that's what the minimum wage was raised to this year. And I assume that next year, assuming inflation is still high, it'll probably go up next year based on inflation. The minimum wage has an impact on your exempt employees, because to be exempt, you have to be paid twice the minimum wage at least. So if you have any exempt employees, they also need to be paid a little more. So monthly, that amount is $5,373.33, or a year, they have to be paid $64,480. And if they don't get paid that much, or somehow they stay below that, then that person is no longer exempt, and you have issues with respect to overtime and minimum overtime and other issues that will come up in the way you pay an exempt employee. Meal and rest breaks would probably also pop up. There are other exemptions that measure the salary that's required to be paid based on the minimum wage that's applicable. And the minimum wage we're talking about here is the state minimum wage, not the local cities. But there are other exemptions that you may be using. There's a computer exemption, different kinds of other exemptions that take into the minimum wage as a base, as a multiple for the minimum wage. So make sure that if you have other people who you're treating exempt, that you take a look at how much they're making a year to make sure that you stay on pace to meet that minimum, so that there continue to be exempt employees and you don't have any issues. This year, COVID rules began to change. I think with a widespread vaccination that has been going on in different places. You know, we're not over it, but we're over the emergency part of COVID. So a lot of the rules that came in as an emergency are pretty much going away. So the first thing that actually is going away is the paid sick leave for COVID related sickness. So if you got before this year, if you got sick, you were entitled to up to 40 hours or 40 hours a week off if you were sick, and then which could be extended to another 40 if it continued. Now those are going away. You don't have to do that anymore. But you got to remember that if a person is actually very sick from COVID, they would still be entitled to potentially leave under FMLA, which is the Family Medical Leave Act, or the CFRA, the California Family Rights Act, or the ADA, the American with Disabilities Act, or the FEHA, the Fair Employment and Housing Act, which protects someone who essentially is disabled. And those are unpaid leaves. You don't have to pay, but the person might be entitled to some benefits with unemployment and stuff like that. The other thing that's going away is that under California OSHA rules, OSHA implemented a rule that they call it the exclusionary pay rule, which basically meant that if somebody got sick at work and they were excluded from work, that the employer was required to continue paying that person. That went away already. I think at the middle of January was the last, that was when it expired. So that's gone. OSHA still has some rules regarding, the prevention of COVID. You have to provide face masks because they're considered secure safety equipment. So there's a lot of preventive things that you can do. They've also implemented a notice change where now you can essentially put it in the bulletin board that somebody might have been exposed to COVID in the workplace. So the notice requirements have changed. So basically what they've been doing is kind of moving away from kind of an emergency set of rules to something that is more just regular rules being implemented. So that's COVID. The one thing that the legislature did was extend the workers' compensation presumption for and on the workplace infection for COVID. So what this did was, if you worked 14 days within 14 days prior to you testing positive, there's a presumption, a rebuttable presumption in workers' comp that injury essentially happened in the workplace. And the idea is that basically this person would then be entitled to workers' compensation insurance. So that remains, and it's been extended until the beginning of for this year. It'll expire on the 1st of 2024. So as I said, we got past the emergency rules. We're going more to kind of a stable set of rules that are designed to still prevent COVID, but the urgency aspect of it, I think we're getting past that. How we come out of this, we don't know. There could be another outbreak. Apparently, there's still new variants coming out. We don't know how that's going to happen, but right now it seems like we're hitting kind of a stable time in COVID. But I think if we hit an emergency, anything spread, we might go back to those rules. But I think for now, I think we're pretty much done. One of the changes, or one of the big changes that came into place this year, this is kind of a new right that's being granted. So AB 1041 essentially amends two laws. It amends the California Family Rights Act and the Healthy Workplace, Healthy Families Act, which is essentially the paid sick leave. And we always use the PSSL as the acronym. It amends both laws to essentially give you the right to take time off to care for that person, even if they don't meet the definition within the rules of what a family member is. So this person would be a designated person. Both laws have a definition of what of who needs to be sick for you to be able to take that time off. So it has to be a family member, which is defined generally as spouse, son, daughter, siblings. I think now you cover grandparents, grandkids. That pretty much is it. So this one kind of gives you the ability to actually take some time off. So let's say that you've been dating someone for a while and they get sick and you need time off. You can actually designate that person, even though they don't fit the definition of what a family member is. You can designate that person, and that essentially you have that person be the person that gives you the ability to take time off to take care of them. Both laws are being amended to give you that ability. You can designate the person when you request it, and but it is especially the CFRA, the definition, and I'll show you the definition in a minute, is designed to cover people who are essentially the equivalent of family. So there is a definition. We just don't know how the courts are going to interpret that. What's the equivalent of a blood relative? So we don't know how it is, but the fact is that somebody can designate someone. And so these are the definitions. So the CFRA, and I'll tell you what the rights under the CFRA and PSL are in a minute. So I want to just kind of a refresher. But under the CFRA, the definition is any individual related by blood or whose association with the employee is the equivalent of a family relationship. So you can see that a girlfriend or a boyfriend, maybe someone that you guys have, you've been living together for a while as husband and wife, that person may not qualify under the traditional definition. That person would qualify. Under the PSSL, the paid sick leave, the definition is a little different, and we don't know how this is going to be treated, but it basically says a person identified by the employee at the time the employee requests the paid sick leave. So basically, it's anyone that you want to consider, taking time off to help them out. So it seems to be a lot more broad and more lenient than the CFRA. We just don't know what the courts will do. But normally, the way the courts view when there's a statute that has two specific differences embedded in them, the court says, well, the legislature intended different things. So it might be that they are getting interpreted to mean different things or to cover different people, but at this time, we just don't know. You can designate the person when you made the request. When you make the request, you don't have to do it in advance, although employers can request that be done. An employer may limit the employee to one designation per 12 months, so one person a year. So you can change that person, but that's what the rules are. So basically, a refresher on the CFRA. Under the CFRA, it applies to any employer that has 5 or more employees, and if you or a family member is sick and you need time off, it gives you up to 12 weeks of unpaid job protected leave. You have to provide, doctor's notes and stuff like that, but you have that right. That's what the CFRA does. This law is essentially very similar to the Family Medical Leave Act, the FMLA. Those two, the FMLA is federal, the CFRA is a state. There's been a lot of changes to the CFRA in terms of coverage. So for example, the FMLA only applies when you have 50 employees. The CFRA applies if you have 5 employees. It used to be that the CFRA applied when you have 50 employees as well. So the CFRA is becoming more protective. And at some point, it probably just take over what the FMLA would do, but both laws would apply. And in different situations, they may apply when the other one doesn't. So for example, in the scenario of a pregnancy, the CFRA doesn't cover pregnancy. So the FMLA leave would be covered under FMLA, but the pregnancy leave for the state would be covered under what they call the PDL, the Pregnancy Disability Law. The CFRA you can save for later, and you can use that as baby bonding time. So there's different variants and different things. So this is one of the areas where HR people really just pull their hair. It's really complicated how these laws play together. But for our purposes, just know that the CFRA does not cover pregnancy disability. It's another law. So the CFRA never runs. So essentially the employee is saving that for later and they can use it. So you can have pregnancy disability and then you can have CFRA time. So you can have 12 weeks of CFRA and all the time in PDL, which is actually 4 months. Pregnancy disability, you have a right to up to 4 months of leave. The employer also has the obligation to designate and track the leave that they give. So if somebody asks for a leave, it's the employer who is supposed to ask for this information and then say, you are covered by this leave and this is what you need to do. And here's a letter that basically explains everything. So it's the employer who has to do that. If the employer doesn't do that, these times don't run. And just be advised that there's other laws that could apply. So this is a very, very, very summarized refresher. The PASIC leave is it was implemented a few years ago. it basically just says that for an employee is entitled to a paid sick leave, time off for certain for diagnosis, treatment, preventive care, and also for to do things with domestic violence, sexual assault, stalking. So this would cover, going to court, going to the police, seeking treatment for domestic violence, sexual assault, on this kind of stalking, getting restraining orders. So you could use this time. So this is you're supposed to accrue 1 hour for every 30 hours of work that you do. You're supposed to accrue up to 3 days. Well, you can accrue up to 48, but in a year you can limit the use to 3 days. You can accrue it on a 1 hour of work equals 30 hours. So you can just grant this thing up front, because tracking the 1 hour for 30 hours of work is actually very complicated and creates a lot of issues. And this should be part of the pay stub that someone gets. And if you get that one wrong, you actually can trigger penalties. So a lot of employers, and this is what I tell some clients, is just grant them 3 days every year, and then just track how much time they're using. So start subtracting instead of adding and subtracting, and kind of keeping track of all those times. It's just complicated. There's some limits. Somebody has to, an employee basically has to work for 90 days. Before that, you can limit the use. Some municipalities, some cities and counties have their own laws. For example, LA has 6 days that they require for paid sick leave. This is the state rule. So depending on where you are, you may have a law or an ordinance from a city that grants more time. Santa Monica has another. I think Pasadena has another. Up north, Emeryville, San Francisco have their own rules, and they have their own requirements. So if you're in one of those, make sure you check with that. One of the other rights that, I guess this one, it was probably already in place, but I think it was a reaction to the Dobbs case out of the U.S. Supreme Court that essentially took away the right to have an abortion. So this basically codifies in the law the right of any employee to essentially to not be discriminated on the basis of reproductive health decision making. So basically, if you're working and maybe the employer knows that you're getting any sort of healthcare treatment regarding your reproduction, so it's not just abortion. It could be doing in vitro or anything like that. Basically, you would be protected. The employer cannot use this as a reason to essentially terminate you or discipline you. In addition, Prop 1 amended the California Constitution to also protect reproductive freedoms. So basically, they're embedding all these rights in all the different places where they could go, just to make sure that if God forbid there's a change in the legislature in California or the California Supreme Court, and somehow this thing, I mean, it's very unlikely, but I think they're just making sure that it's everywhere and that this right is protected. The other big one is it actually has done some has rocked some boats, but it basically is not that complicated. It basically this makes it on this AB 2188. And AB, it means it's one of the houses in the legislature. That's the Assembly Bill 2188. SB means Senate bill. It basically makes it unlawful for an employer to discriminate or penalize a person in the hiring, termination, or condition of employment, essentially for using cannabis, marijuana, off the job and away from the workplace, or to use a test that tests for non-psychoactive cannabis metabolites in the hair, blood, urine, or other fluid. What that means is, and I'll explain what they're going after here. But one, this law is going to be embedded in the Fair Employment and Housing Act, which is where you find all the anti-discrimination provisions. It will also go into effect as of 1/1 of next year. This is not in place yet, although it has passed and it's been signed by the governor. So it is a law, but it's not in play at this point. It will go into effect in January 1st of next year. The employer is permitted to essentially discriminate or take into account a valid test that does not test for non-psychoactive cannabis metabolites. And this is what they mean by it. The statute has this. So THC is the psychoactive compound that essentially gives you the high. When you ingest that, the body essentially breaks it up and stores it in the body. Once that happens, it is no longer impacting your mental capacities. But a lot of tests were testing for this non-psychoactive metabolite, and they were coming back positive. The problem that this law is trying to address is, well, that person could have smoked or used marijuana 3 weeks ago. So at the moment that they tested, this person was not high. And so they're trying to prevent that. The employer is still able to test if they have an indication that somebody's high. The law doesn't allow somebody to show up high, just like they wouldn't allow anybody to show up drunk. The employer always has the right to discipline that employee and even terminate that employee for those reasons. What it's trying to do is, since the use of marijuana now is legal, they don't want the employer to be able to punish you for something that you do on the weekend. So that's pretty much what this law is designed to do. The law does not impact federal law obligations imposed on employers. So if federal law says you need to test, and then you have to do that, so it allows you to comply. You can still have drug and alcohol-free workplace policies. You just need to make sure that you comply with this thing. And remember, the idea is not to allow the person to show up high. It's just like you wouldn't do it for somebody show up drunk. It's the idea is that, they're using this stuff on their own free time, and the employer should not have the right to tell someone to do something on the weekend if they're not scheduled to work. And the employee still cannot possess marijuana, be impaired, or use cannabis on the job. So that's the provision does not apply to building and construction trades. So you're talking in the construction area that this law would not apply. The law does not apply to applicants or employees who are being hired for a position where the federal government requires an investigation or some sort of security clearance. In about 6 or 7 years ago, there was a case when California first allowed marijuana use for health reasons. There was a case called Ross versus Raging Wire, where the employee basically sought an accommodation for medical marijuana use because he had been injured and he was in pain, and he found that marijuana actually helped for that. So the guy applied for a job, and he tested positive for having used. The California Supreme Court was one of the first courts that decided that basically this is not protected activity. So the employer wasn't required to even engage in the interactive process or provide a reasonable accommodation. With the changes in the law that happened, I think it undermines some of that holding. So now I think if somebody requires or requests a reasonable accommodation, maybe an employer needs to consider the possibility that maybe now you would be required to at least engage in the interactive process and see if there's a way for somebody to be able to use marijuana for medical reasons. So that case is the reasoning has been undermined. So there might be a change in the law of the case. I haven't seen any case that actually addresses this issue. And it would probably mean that the California Supreme Court has to take up a case, and I haven't seen anything on that. We also have a new leave that was implemented this year. That's bereavement leave. This law amends the CFRA, the one that provides the 12 weeks of leave time to take care of yourself if you're ill or someone or a family member. This new law basically grants 5 days of unpaid bereavement leave for the death of a family member. This amount of this 5 days is in addition to the 12 weeks that they would normally get if you were sick. So you're getting this extra 5 days. There are some requirements. Family member includes a spouse, child, sibling, grandparent, grandchild, domestic partner, or parent-in-law. Whether you can designate a person, I don't know, although the CFRA is being amended for that. And my sense is that it'll probably cover someone who's designated. Again, we're going here to someone, let's say that you're living with somebody and that person passes for whatever reason, and you want to take time off. That person is you could probably do a designation of that person. The statute itself doesn't do it, but I think it probably will be done, or it would be read that way. For the employee to get this leave, they have to have worked at least 30 days prior to the start of the leave. It covers 5 employees. It covers employers with 5 or more employees, and the state and its subdivision. So you're talking about cities, counties, and all that other different special districts. The leave must be completed within 3 months of death. One of the things that came up in that discussion with one of my clients was whether, is this on a per occurrence? So let's say that somebody has multiple deaths in the family. Would they be entitled to, let's say that they have 2 deaths, are they entitled to 5 days under this law in a year, or are they entitled to 10 days under this law? And the law is not clear, but they didn't put any limit. So my sense is that if you have multiple deaths, you probably need to provide multiple leaves for each employee. The other interesting scenario is, what if you have multiple deaths in a one occurrence? So if you have one accident and 3 people die in your family, are you entitled to 5 days or 15 days? The statute is not clear on that, and I don't know if they will limit it to 5 days, and this would be something that the courts or the legislature may fix, but that's unclear. But if you have multiple deaths in a year, it looks like you would probably have to give 5 days for each of those deaths. There was other big changes that have been essentially being implemented, but they've been coming down the pipe for a while. There's a pay transparency and reporting of essentially of pay information. SB Senate Bill 1162 essentially require this 2 requirements. So the first requirement is the first requirement is basically the employer with 100 employees or more must submit a pay data report of the prior year. So this would be, if it was in place, it would be for 2022, you're submitting data this year. And you have to submit it by the 2nd Wednesday of May of 2023. Then it would be due each year thereafter, or at the same time. This requirement applies even if the employees are hired through a contractor. So here you may have a situation where a contractor is providing your employees. You still have to provide this information, and the contractor is required under the statute to provide this information so that you comply. And there's penalties in there regarding whose obligations and whose breach of that obligation would result. The law requires the law also requires that any employer with 15 or more employees to provide paid data to applicants and current employees, and also imposes some data retention, so some payroll retention information. So you're talking about any pay stubs or anything you should essentially store it for a certain amount of time, and we'll get to it in a minute. So the pay reporting law, that aspect of it, basically the report must contain the number of employees by race, ethnicity, and sex in each of the following categories. So basically this is anyone in your organization, anywhere from executives to professionals, technicians, sales, admin workers, craft workers, operatives, laborers, helpers, and service workers. So you need to provide a breakdown of all of those in that report. The number of employees whose you need to also include the number of employees whose annual salaries fall within the band of the U.S. Labor Statistics report or survey. And that's the address where you can find this. The report is released in March. I tried to find it. It doesn't have last year, so I couldn't see what it looks like, but that's where you can find it, and you would have to provide this information. The report also has to include for each category in the list of employees that you would get under this report, under this survey of the U.S. Bureau of Labor Statistics, you have to include the median and mean hourly rate. And I'm not going to get into the statistics, but basically, essentially you're looking for the average rate and also the midpoint on the pay salary of those employees are included. For the data report, an employer must create a snapshot counting all the employees in a specific category by race, ethnicity, and sex during a period of the pay period during the employer's choosing from October 1st to the end of the year, of the reporting year. So for this year, it would be October 1st, 2022 to December 31st, 2022. You would select a pay period and you capture those employees, and that's your basis for all of these things. To calculate the median, mean, and hourly rate, essentially you would take all the W-2 wages that you would pay an employee and use that data to determine what that hourly rate. So essentially you would be dividing it by the number of hours that employee worked. That will give you the hourly rate. The mean and average, you would essentially take all the wages and divide it by the number of employees by the number of hours. And so you end up with this data that you would have to provide. Hours worked by each employee in each pay band in the reporting year. So you would have to provide the hours worked. So that's the data that you would use to essentially determine the hourly rate and mean. So they want to see the data for each employee in terms of the hours worked. And the data will include the employers. Essentially, this is an industry code that is used to, classify employers. So you could have industry, you could have a service, you could have financial, you could have different, so they have different codes. So you need to look up what that system would be for you. I tried doing a search and I couldn't find it, but I'm sure that maybe I just didn't do the right search. But it is something that you can get pretty sure online. If the employer fails to report the CRD, the California, the Civil Rights Department, so this is what used to be the DFEH, the Department of Fair Employment and Housing. Now it's called the Civil Rights Department, may sue the employer for compliance. The CRD will be able to obtain attorney's fees and costs, and penalties may be imposed not to exceed 100 per employee for the first violation, and not to exceed 200 per employee for subsequent violations. So if you have a decent amount of employees, this could be a significant amount. On top of that, you may have to pay any fees. Whether the employees have the right to sue, I don't think they do on this. This is something that the Civil Rights Department would pursue. They may change that in the future where, and also whether PAGA would allow a case. It isn't clear, but it probably could be something that in a PAGA case could be asserted. We just don't know at this point. The pay transparency is the one that basically says that the employer has to essentially provide certain information. So as an initial point, an employer, this was something that existed before, an employer cannot inquire or rely on the salary history, which includes benefits to this of an applicant, to decide whether the applicant will be hired or the amount that this person is going to be paid. In fact, the employer may not even ask for this information. That's prohibited. That was already in place. Now this law is being strengthened by essentially requiring that the employer provide more information to applicants and to their current employees. So on a reasonable request, the employer must provide a pay scale for the position that the applicant is applying for. Also on request, the employee, a current employee may ask for the pay scale of the current position they're in. Now, they cannot ask for information of other people, but they can ask for the position of other positions. In other words, you can't say, I want to know Oscar's salary, but you can say, well, Oscar is the HR manager. I want to know what an HR manager's pay scale is. And so you can provide a pay scale, or you can actually provide the actual data. So you can provide a range, or you can provide the actual amount. For any posting of a job, you have to provide a pay scale of essentially what the employer thinks they're going to be paying for that position, so that the employer has an idea what to ask, or even if it pays enough. Here, the idea is that before, the employer could say, ask the applicant and say, what do you expect to get paid? And if it was lower than what they were prepared to pay, they would just pay the lower amount. So the idea here is to essentially make the information transparent. And so the employer can say, well, I'm looking for this amount or whatever, even if they thought that they, could do the job for less. The employer is required to maintain the records of with the job title and wage rate history for the duration of the employment, plus 3 years after this person leaves. The idea here is essentially, you would normally keep the records of a current employee, but you should be keeping records probably more than 3 years. I think for wage and employment information, it should be between 5 and 6, because those are the statute of limitations of issues that may come up. And so you want to make sure you cover that. 3 years is actually, I think, too small of a time for you to retain those records. So I would suggest that you do 5 or 6, 6 probably being on the safer side. An employer with 15 or more employees who relies on a third party to announce. So this is if you go to a recruiter and you post this, you are still required to provide a pay scale to that third party, and that third party must then put it in whatever publication. So you can't get around this rule by saying, well, we're just using a recruiter, so we're not required to do it. We're not doing it. If you're doing that, you're still required to do it. An employer that does not comply may complain to the labor commissioner. The employee can file a complaint in court and seek injunctive relief, as well as other remedies. They don't really say other remedies, but basically you probably will get all the different types of penalties and damages and everything that you're entitled to. So they give the court the discretion to give you as many remedies as you can come up with. If found guilty, an employer may have to pay a civil penalty of not less than 100 and no more than 10,000 per violation. So there's a big range there. So the court has a discretion, and where you end up, it's just difficult to determine. Basically, they will take into different facts into consideration. The statute does say that the labor commissioner may determine the penalty based on the totality of circumstances, including whether there were prior violations. So basically, all this means is the labor commissioner can just come up with the different facts as to why an amount and try to justify it, and then the court will just come up with something. But because the labor commissioner is asking, my sense is that the court is probably going to follow the labor commissioner recommendation unless that's out of whack. So if they stay within a reasonable bound, I think the courts would probably go with that. For the first violation, the employer may cure by showing all postings, including pay scale as required by law. So if you have the first time that this happens, you can actually fix the things. After that, you probably won't. So if you essentially get caught on the first time, essentially you can just try to fix everything, make sure that all the postings now have this, that you have all the postings in the right places, and you should be okay. But you should be more proactive rather than just get to that point. There's also a new anti-retaliation law, and we're getting close to the close to the end here. This statute, SB 1044, basically what it does is it gives the employee rights to protect themselves in situations of emergency. So in an event of an emergency, the employer cannot take or threaten actions against the employee for refusing to report to work or leave the workplace or worksite if the employee believes it is unsafe. So think here, during an earthquake, somebody decides to take off and they don't tell the employer, you wouldn't be able to fire that person if they felt that it was unsafe. You cannot prevent the employer from using their cell phone or other communication device to seek emergency assistance, assessing the safety of the situation, or communicate to verify. I don't know if this would ever even happen in real time, but I mean, I suppose there are policies that say that employers cannot use their cell phone while they're on the job. So this basically says if there's an emergency, a person who feels unsafe where they are, they could take off and you cannot discipline them. PAGA claims are possible, and PAGA here is the Private Attorney General's Act claim. This is the one where an employer can aggregate the claims of all their employees and sue, essentially not necessarily as a class basis, but as a collective action basis. So you still aggregate, and it could be a big issue if you have a lot of employers. Employer has the right to fix these issues under PAGA if they come up. So we don't know how this is going to play out. California has had floods, has had fires, and it has the earthquakes, and also we had the riots. Any of those would qualify. So there are some exemptions, and I'll tell you the definition of what an emergency is, but there are some exemptions, and here are the traditional exemptions. So you got the first responders, disaster workers, employee required by law to be there in a case of emergency, employee or contractor in a healthcare facility, military-based personnel in this industrial sector, essential workers in a nuclear power plant, employee working in utility, communication, energy, or roadside assistance, engaged in the specific purpose of fixing an emergency situation, and even licensed residential care facilities. Some bank employees and others are exempt. So these are people that basically are expected to be working when there's an emergency, but everybody else would have those rights. These people don't have that ability. So first responders have to be working during that time. That's their job. So what is an emergency? Basically, it's an emergency that has two definitions: conditions of disaster or extreme peril to safety of persons or property as the workplace and worksite caused by natural forces or a criminal act. So here, it's not just rain, earthquakes, fires. If the fire was started by somebody, or even if there was a riot, probably this would be considered an emergency situation. Also, if there is an order to evacuate a workplace or worksite, a worker's home, or the school of a worker's child due to a natural disaster or criminal act, that would be an emergency. The statute actually says that the health pandemic is not an emergency situation, so COVID would not have been covered. Reasonable belief, so the person has to have a reasonable belief that they're in danger. So basically, this would be what a reasonable person would think is dangerous under the facts known by them at the time. So this is kind of the law fiction of a reasonable person based on with the facts presented at the time. If you can say that that person, a reasonable person, would find that the current situation is in danger, that would be covered. Okay, we're getting to the end here, and I know I'm going fast, but I only have about 5 more minutes. And this one it's one that a law that has been in place, but it was amended, and it now may cover some employers. So this one will cover bigger employers but I threw it in there because if it does, it can impose some serious requirements on that employer. So the California Consumer Privacy Act was amended to eliminate an exception before that law didn't apply to employers or in the employment setting. Now that exemption has been eliminated, so now employers could be covered, but a cover employer is a very specific business. So this is what who is covered. It applies to all for-profit businesses, so nonprofits will not be covered, that collect, share, or sell a California consumer's personal information. And here, personal information, talking address, name, phone number, stuff like that. Essentially, what would be in your credit report. That has annual revenues in excess of 25 million, so it's a fairly big business. Possesses personal information of 50 or more consumers, or earns more than half of their annual revenues selling consumers' personal data. So basically, it's going after the people who are aggregating this information and selling it. But it also, number one, and you only have to satisfy one of those if you satisfy the other parts to be covered. So if you're 25 million, you're for profit, and you obviously collect information from consumers, and that would be the employment information you collect from your employees, you are covered, and you get obligations imposed by this privacy law. And this is what basically the law grants. And this is a very summarized version of it, that the law is actually very detailed and it covers a bunch of stuff. So this is very summarized. So the CCPA grants consumers the following rights. So the right to know. So they have the right to request a disclosure of what personal information is being collected, from whom it is being collected, and if it is being sold, to whom it is being sold. So this is one of the main rights. The other one is right to delete. So if there's any information that this company has in terms of the information that's been collected, the consumer, in this case, which could be an employee, would have the right to request that the information be deleted. And here it would be something where maybe the information is inaccurate. You have the right to opt out and the right to opt in of this, of you being included. And I think we've seen some of those in different parts when you've been signing up for stuff, or even the bank is giving you those rights. And I think that's the law kind of working itself through. But you do get these mailers every now and then, and that's what that is. So you have the right to opt out from your information being sold or share with anyone. And there's you can opt in. The opt-in is essentially targeted to underage consumers. If you exercise the right, you have the right to not be discriminated against. You have the right to essentially file a lawsuit for data breaches under the law. So if somebody has this information and they somehow are negligent in the way they keep this information, you could actually file a lawsuit against them. You have the right to correct any inaccurate information, and you can actually limit the use and disclosure of sensitive personal information, which is probably more dealing with healthcare information and social security, financial information. So the law gives the consumer a tremendous amount of rights. So if it applies to you, you should seek help, because this is not something that employment attorneys we've dealt with, because it didn't apply in our context. But now we're going to have to deal with it. But if it applies to you, you want to make sure that you're doing the disclosures that you need to be doing, obtaining whatever acknowledgements you need to do, and making sure that you have a process by which your employees are able to submit requests for deletion and all the other stuff, so that they have the right to exercise their rights under this privacy law. So this is a big change, mostly for bigger companies, but $25 million may be a lot, but company could hit there, could get there pretty fast. So this is one that you may want to consider. And with that, that's all the laws. There are some other laws that are kind of less relevant, but that pretty much is the presentation. I think I got it in just in time. So thank you for attending, and I hope that the presentation was helpful. I will be happy to take some questions if we have the ability to.
Thank you, Oscar, for walking us through that. And it's, it's amazing what you could deliver in an hour, because it's a lot of information that you just consolidated and broke down for us. And there are some questions that are that we received. One of the questions is, as it relates to bereavement law, how many days are paid by the employer?
The CFRA leave is not paid. So the employee would be entitled to the 5 days, but they're not paid. But they would have, under the CFRA, they would have the right to their job when they return. So you can't really fire or discipline them in any way. And they also would have the right to use any of the accrued vacation or PTO if they have that. So you could get those paid that way. But the leave itself is not a paid leave. The only paid leave is the one that I told you, the PSSL, which is sick leave.
Okay. And another question, thank you for that. And another question is on with regards to the cannabis or the marijuana use. And you mentioned it's still, it's something that it's going to come into the future, but can employers test if they suspect a user on, like, if one of their employees, if they suspect that this person may be under the influence, are they able to tell this person, okay, we'd like you to submit for a test at this moment? How does an employer or human resource manager navigate those kind of on the floor situations?
Yeah, so there's two types of testing, different types of testing policies that you have. So you can have pre-hire testing, and there's a specific set of laws that cover that. And then, post-offer, you can do that, or post-hire, you can have a random policy. Those are very difficult to implement and everything. Then you can have a post-accident rule that as soon as when somebody has an accident, you can have kind of an automatic testing. But if somebody shows up and the supervisor or the employer, basically sees the symptoms of somebody being inebriated or high, the employer has always had the ability to require a test. And this goes to the law where it says that, the employee still doesn't have the right to show up drunk or high if the employer has any indication. And it should be something where the employer needs to document that, this person has slurred speech, their bloodshot eyes, they're wobbly, so you have to have the indications. But let's say that you do, then you definitely have the right to request that the person be tested, because the violation there is that the person essentially is showing up drunk or high, and that would be illegal, and that has always been a right for different reasons, but basically, especially if you have safety and security issues. But even if somebody just shows up high, that's reason enough for you to require a test, and if it comes back positive, you can take whatever disciplinary action you want to take.
There's more questions that arise from that on my end, from an employment practices liability and somebody being stereotyped or being tested because they look or behave a particular way, and even though they may not be under the substance of anything. But that's a separate conversation, I think, that we can go into.
Well, yeah, but and just to address that one, I think you touch on a very interesting point. One, you cannot discriminate against someone, and just because they look a certain way. But if the employer, if they have a reasonable basis for believing in it, even if they get it wrong, they would be protected. So in other words, if somebody shows up and let's say they're taking a legal medication and somehow that, it's impacting, but they think that the person is high and they require the test, the person could sue them for violation of privacy or invasion of privacy. but the employer could still have the defense. So look, this person was showing indications that they were high, and we went with that, and it was, you know, witnessed by different people. So, you know, when it comes to these things, the summary that I present here, and this is why the presentation of the 22nd is going to be important, is that these rules have to be implemented. And, you know, it's when the rubber meets the road, you start seeing kind of the practical impact of what these rules are and how they impact the employee, the employer, insurance, potential lawsuits. So they do have a very clear impact on the way employers do business.
Thank you, Oscar. And, you know, we are at 11:30. This completes the formal part of our presentation. And we're going to stay a few more minutes because there's another question that's been asked. So thank you for joining us today. Remember that on February 22nd, we're going to be expanding on these laws and talking about how to implement them. How do you bring these from a legislative change? How do you embrace it? How do you have your culture buy into it? And how do you make it part of your organizational culture going forward so that you stay within compliance? And we'll have Oscar will be joining us on that conversation, and we'll also have human resource specialist Carmen Torres joining us. So we'll have both the legal side and the human resource side walking us through how to implement this. So thank you for joining us. If you need to disconnect, the presentation formal part of it is complete, and we'll stay on a few more minutes to answer some questions. Oscar, one of the questions that came in is if an employer currently pays for 3 days of bereavement leave, can they offer 3 paid days and 2 unpaid days?
Yeah, the answer is yes. So you can always go. So the way you think about this laws is they set up a floor. You can always go higher. So if your policy says that you're giving them 3 days, you still have to give them the 5 days, but they don't have to be paid. So you just need to change your policy to say, you know, we're going to give you up to 3 days. And then, you know, on those other 2 days, if you want to use your vacation time, you can do that. You know, you might want to also change the policy to say, to implement the other requirements. For example, you have to use this time within 3 months of the death. So there are other requirements in the law that you would want to modify or include in the new policy. But yeah, since the leave is not paid, the fact that you pay 3 and you want to keep that, that's fine. And it won't create any additional obligations, you know, other than the ones that you want to create.
Wonderful. And one last question that we have is, you know, as it relates to the paid time off, right? City of Los Angeles has 48 hours. The state of California has 3 days, 24 hours. So there's a difference if you go from city to county to state to federal. There's like a different set of compliance rules. And it really, you know, if you have multiple locations in different cities, it creates these other, you know, being able to understand the legislation behind every city and also the state. Can an employer opt to create a paid time off, just say lump sum that includes, I've seen some human resource employee manuals that the employer will say, we're just going to give you X amount of days. That includes PTO, that includes vacation time, that includes paid time off. And my sense is that they've done it to just make it simpler to comply with all the different legislations that are out there.
So the answer is yes, as long as you make sure you cover all the laws. Like I said, all these laws have floors, so make sure that you cover, you know, the floor for the count for the state is 3 days. The city is 6 days, and different cities have different requirements. But you can create a plan that basically satisfies everything. You can do that. When the new law, the paid sick leave law, came into place, there was a way to essentially grandfather some of the laws as long as you kind of had the things. I think that time pretty much passed. But you can still create a policy that kind of covers the location where you are. You know, every law sets up a minimum, but that means that you have to satisfy the lowest part of the last law that applies to you. So if you're in the city of LA, you have to give the 6 days. and satisfy the law. When you do that, you're going to satisfy the state, and you probably satisfy different places. There are some issues that get created if you have people who are basically outside of the city of LA. Say they live in Ventura County and you're not covered, but you have people working in LA. That it creates some very tricky situations, way more complicated than we can address here. But
Yeah.
that also may bring into play some issues. So you need to be very mindful if you have people moving around. And we're talking here people who do sales or construction. Sometimes you can do construction in a city, county. You can go to Orange County. You can do San Bernardino County. You can do Ventura. And you have people working in and out of the city, and there's jurisdictional requirements. But if that law applies, then you kind of have to comply with it. I haven't heard any huge issues with the city being coming after people, but I mean, at some point they could.
It'll be, yeah.
Yeah,
and you're bringing forth one of the online conversations we're going to be bringing in likely in March, I believe, is embracing the mobile worker, right? And that mobile worker or team member may be in a different city, in a different state, or maybe moving from state to state, state to state. And is how do organizations develop policies and practices that keep them in compliance and also offer this lifestyle that many team members are wanting and looking for. So with that, thank you, Oscar, for bringing this presentation. Once again, on February 22nd, we're going to have our follow-up to this conversation on how to implement these laws and legislations coming forth. We're also going to send you a survey. One of the things that we're now looking for is your feedback. Like, out of everything that we went over in this presentation, what are the conversations, the laws that you think we should be expanding on in our conversation coming February 2nd. So stay tuned. We'll send you an email with a survey to get your insights and feedback. And the idea is to tailor these conversations in a way that it benefits you, in a way that it brings you insight, it brings you knowledge, and it gives you that access to being able to think and plan ahead. Planning ahead is, I think, it's the best way to manage a lot of these issues, because if we do it effectively, they don't become issues. So thank you, everyone, for joining us here today. Have an amazing week, and we'll see you in the next conversation.
Thank you.